Welcome everyone to the biannual immigration and visa seminar. Today we'll discuss working visas. As it is already tradition, I would say, Andy Ingebrigtsen will present will do the whole presentation. He's an attorney from Ellis Porter, and without further ado, I would say we jump right into it. If you have questions, you can post them in the chat. And I don't know, Andy, how you want to handle it. Either after the presentation, they can unmute and ask, or is it okay if they interrupt?
Yeah, if people want to jump in at any time, that's fine. We will have a chance for question and answer at the end. So whatever works, doesn't bother me.
All right, sounds good. Then I would say the stage is yours.
All right. Well, thanks for having us again. Like Thomas said, my name is Andy Ingebrigtsen. I'm one of the senior attorneys and directors of high-skilled immigration at Ellis Porter. I think my colleague Natalia will be joining us today. She is a senior attorney and director of our employment-based division. So today we're going to focus mostly on non-immigrant visas, work visas, opportunities after your postdoc period is over, what comes next. So just to give you a little background about Ellis Porter to get started, we are a full service immigration law firm based out of Troy, Michigan in the Detroit area. Also have offices in Ann Arbor and London. We are one of the largest immigration law firms in the country. I think we're up to over 200 attorneys and professionals now, so my number is a little outdated there. But we do full service immigration, basically everything from asylum, family-based, employment-based, green card, everything you need. We try to be kind of the one-stop shop for that. Our high-skilled immigration team in particular is one of the largest in the U.S. Those focus largely on green cards, but also on O1 petitions that we'll be talking about a little bit today. So after your postdoc period, there's kind of two main areas to go to. I've got OPT STEM up here, but that's more for people who are just graduating, not for postdocs quite so much. H-1B and O1 are the main pathways that we're going to talk about today. Just to touch on OPT STEM a little bit, it is 1 to 3 years after your graduation on an F1 visa. It's 1 year as a starter and then an additional 2 years if you're in a STEM discipline. So you can have up to 3 years there. For most people, that's going to be kind of the post years after graduation, and so we're going to focus mostly on what comes after your OPT runs out. So like I said, two main pathways there, the H-1B and the O1. And just real quick, Natalia, are you here?
Hi, Andy.
Hey, there we go. I will let you handle the H-1B stuff.
Thank you so much. And sorry for my tardiness. My Zoom was actually updating. So thank you. Yep, this is Natalia Saraf from Ellis Porter. And as Andy mentioned, this kind of one of the main pathways after you're on an F1 is typically to go ahead and transition and convert your status to H-1B. It's an employer-sponsored visa. There's two main ways on the H-1B. You've got the CAP subject or the CAP exempt employers. So while it's companies employer sponsored, there's some that have to go through a CAP subject, which means that there's a lottery or a registration-based system that you have to go through. And typically there's anywhere from a 30 to 40% chance of being selected each year. We just ended the fiscal year 25 lottery submissions. We haven't gotten the stats of how many folks were submitted, but historically it's been about 30 to 40% chance of being chosen. In this round, we're thinking about the same. Now, if you aren't working for a CAP subject employer, which is pretty much everybody that's a for-profit institute, you could be working for a CAP exempt employer, which would be in universities and some nonprofit or government agencies. And with the benefit of working for a CAP exempt employer, you don't have to register and go through the lottery process. It can be applied for at any time. But either way, if you're going for a CAP subject or a CAP exempt H-1B, there is a max of 6 years on an H-1B total. So you could actually leave the US, recapture any of that unused time. But either way, it's a 6-year maximum, and there's times to extend it and with different circumstances. Typically, we recommend that you start with asking your hiring manager or your prospective employer if they're offering H-1B sponsorship, and if so, if there's any restrictions on it. Do they only sponsor folks in certain positions that hold certain salaries or certain degree requirements? So you just have to find out from your employer if they're willing to sponsor you. And if they have any questions, of course, they can speak to our team. We'll be happy to guide them on the process. We also recommend that you apply early. Unofficial reports say that they received a little over $500,000 in just last year's lottery. That was fiscal year for 24. This year, we're estimating about that same amount of submissions. Now, the lotteries run a little bit differently, but overall, there's still a lot more talented individuals out there that are foreign nationals. And this is the typical transition if you're not extraordinary or meet the threshold for the O1. This is the typical path to H-1Bs. So the effective date of the H-1B is October 1st of each year. And that's again for those CAP subject employers. So you typically will file in March for a registration. You'll find out if you're selected by April 1st. You'll submit the filing between April 1st and June 30th. And then on October 1st, you'd automatically switch from F1 to H-1B if, again, you were chosen and you've gone through those processes. Now, for CAP exempt employers, those are those universities and nonprofit organizations. They can petition for an H-1B worker anytime throughout the year. There's no limit, there's no cap lottery or anything like that. So extensions, now after you've already applied for an H-1B and now you're up for an extension or an amendment, those don't have to go through that lottery process. So again, there's no requirement for you to go through the 30 or 40% chance of being selected. You just can apply for an extension 6 months before expiration. And of course, if you transfer to a new employer, you don't have to go through the lottery again. And whether it's a transfer or an extension or even a cap subject case or even a cap exempt case, you can always file under premium processing right now. Again, there's that 6-year maximum stay in the U.S. on an H-1B unless you've obtained an approved I-140, which if you attend our green card session, we'll talk about how you can get an approved I-140, whether it's through your employer or through a self-sponsored petition. But then if you do get an approved I-140, you can extend beyond the 6 years until you get your green card. Now, if you are married or have any dependent children, your spouse and dependent children can accompany you on a dependent visa. So when you're on an F1, they're on F2. When you're on an H-1B, they're on an H-4 dependent visa. And in certain circumstances, your H-4 spouse can apply for work authorization if you, the H-1B principal, have an approved I-140.
All right. Thanks, Natalia. I'm going to dive into the O1s, which is kind of that second option we talked about. I think that O1 and H-1B kind of complement each other in a lot of ways. There's a lot of the things that make an H-1B difficult, and O1 can make a little bit easier, but it's a trade-off. The O1 has some things that are less desirable compared to an H-1B. So I'm going to kind of compare and contrast the two and go over the requirements for the O1. So the O1, like the H-1B, is employer sponsored. You do need a specific job offer, and the employer has to file a petition on your behalf. Like the H-1B, premium processing is available, so you can get a decision in 15 business days. So it can be a pretty quick turnaround there. The main benefits of the O1 are, A, it has more flexibility than an H-1B. H-1B can be pretty strict with the title and duties and salary requirements. It can be very limiting in who can qualify for an H-1B. An O1 doesn't have those limitations. An O1 can, in theory, be petitioned for anybody if that person has extraordinary ability and the position requires extraordinary ability. So there's more flexibility in the types of jobs that can qualify for an O1. You can also apply any time of year, regardless of whether the employer is private, a private for-profit company, or an academic institution or a nonprofit. Doesn't matter for an O1. There's no cap, so there's no lottery, and there's no time that you have to start. So this makes the O1 a very attractive option for people who want to go into industry, but who A, didn't get selected in the lottery, or B, are looking to make that transition into industry at the wrong time of year. Say you want to begin January 1st. Well, if it's for a for-profit employer, an H-1B is not going to let you do that until the next October. An O-1, you can start anytime. So again, a lot more flexibility. So especially for people who are looking to go into industry, the O-1 can be a really enticing option. Another potential benefit or negative, depending on how you look at it, is that an O-1's fees can be paid by the employer or by the employee or split between them. Generally, most H-1B fees need to be paid by the employer. Some employers are less willing to sponsor H-1Bs because of the cost associated with it. If you're willing to pay the cost yourself, it can be easier to talk an employer into an O-1 because they don't have to pay anything, depending on what you're able to work out with them. Now, I'm sure everyone would prefer not to pay the O-1 fees themselves. That's a point that you can negotiate with an employer, and that gives a little more leverage in those negotiations. So again, flexibility is kind of the key word with O-1. There's more flexibility in who can pay. And then the other thing that can be very attractive is that the employer doesn't have a ton of work to do for an O-1. The H-1B is more focused on the position and the employer and kind of those requirements. The O-1 is very focused on you as an individual, and that means the employer's role is pretty hands-off. And again, that can be attractive for a lot of employers that don't want to deal with going through the H-1B process. They don't want to worry about immigration stuff at all. The O-1 can really simplify the process from the employer perspective. They do need to sign the forms because they are the petitioner. They do need to provide a support letter, but outside of that, most employers have relatively little work to do for an O-1. So again, that can be a really attractive point of negotiation when you're talking to prospective employers, particularly in industry, particularly smaller startups or companies that don't have a ton of immigration experience. They can find that to be a really positive point, that they don't have to do a whole lot. They don't have to pay a whole lot. They can just, hand off the O-1 to us, and then you can start working for them when you get approved. That's a much simpler process for them. So all these positives with the O-1, all this extra flexibility. Why doesn't everyone just do the O-1? Well, it's a lot harder to get approved for an O-1 because you have to have extraordinary ability. That's the basic requirement for the O-1, is that you have extraordinary ability in your field of expertise. Usually that means that you are at the very top of your field and have sustained a claim. A lot of people get very concerned when they hear those words, say, I'm just a postdoc, I'm not super advanced in my career, how can I be at the top of my field? The O-1's requirements are actually fairly lenient in that regard, and they can be satisfied a lot of ways. So a lot of people can qualify for an O-1, but it is not quite as straightforward as an H-1B, where it's more focused on the position that's being applied for. So we're going to go through what the O-1 requirements are. And I do see a question real quick. Is extraordinary ability for O-1 the same as I-140? Basically, yeah, the O-1 requirements and the EB-1A I-140 requirements both are extraordinary ability. The requirements are very, very similar. There are some very minor differences between them, but they're basically the same type of category. I will say the O-1 tends to be adjudicated much more leniently. So it is easier to get approved for an O-1 than it would be for an EB-1A extraordinary ability case. But that's a good question. It's a very similar case type. So diving into some of the O-1 requirements, what do we actually have to show? Well, the first way you can get an O-1 is if you have a major international award, a Nobel Prize, a Pulitzer, an Oscar, an Olympic medal. I'm going to assume most people don't have those things. That's okay. That's just one of the ways to get an O-1. Fortunately, that is not the only way, and it is a pretty uncommon way. Very few people have those credentials, and so almost everyone is looking to this other option, which is that there are 8 available regulatory criteria, and we need to satisfy at least 3 of them. So I'm going to kind of walk through those 8 criteria, which are the easiest to satisfy, which you might want to be thinking about and focusing on improving if an O-1 is something that you're looking for in the future. Number one is awards. This is a lesser award compared to those major international awards I was talking about. They're still awards for excellence in your field, but they might be from a professional organization, from your university, from a grant funding program. You know, they're still awards. They're still showing the value and importance of your work, but they're not quite as difficult to achieve. And there may be something that's more achievable for somebody relatively early in their career. That's one possible criterion. Another is membership. I'll be honest, membership can be pretty tough. The types of memberships that USCIS wants to see are pretty strict. It can't just be something like paying dues or, you know, having a certain amount of experience. Usually it's got to be a membership that's reserved for people who have done something truly outstanding in their field. So that can be a pretty tall bar to jump over. And I'd say that most people do not claim that particular criterion, but it is an option. And a potential example, just to throw something out, senior member of IEEE, so not just your regular membership level, but kind of that next level up is something that you could potentially claim here. Next criterion is published material about your work. This is going to be articles by other people about your work. The main key here is that they're independent articles. So this is not your university, for instance, issuing a press release on your work. That would be something that is going to be seen as more self-serving and not necessarily indicative of how great your work is. So this should be something like a website writing an article about the work that you've done, the research you've done. Potentially, if you're publishing in a journal, the journal invites somebody to give a commentary on your article. That could be something that qualifies here. Maybe you go on a podcast and give a talk on the research you're doing. That's something that could potentially work here. So it's your work being featured by other people in some type of media format. The big key is that the media does have to be relatively significant. If you go on a podcast, you don't want it to be something with like 5 listeners. You know, the bigger, the better. The more important the venue is, the better it's going to look. But there's a lot of options that can fall into this criterion, so it is a common one to claim. The fourth one I'd say is probably one of the 2 easiest criteria to claim, and one that we recommend for pretty much everyone going through the O1 process is judge of the work of others, which is very commonly satisfied by peer review experience. The type of peer review work doesn't matter so much. Obviously, if you're doing peer review for a nature journal, that's going to look really great. But even peer review for a lesser known or lower impact journal can still qualify for this particular criterion. There's no like firm cutoff the number of peer reviews you need to do. Even 1 or 2 should technically satisfy this criterion. We typically say 5 to 10 is a good number to aim for to make sure we have something very solid to claim here. But it's something that just about everyone who's worked in academia has the opportunity to do. And so it's something that most people are able to satisfy. The 5th criterion, original contributions of major significance. So basically, you have made contributions to your field that are original and that have been recognized as majorly significant. This is a very broad criterion, and it can be satisfied lots of different ways. But what we see in practice is that USCIS places a very heavy emphasis on citations for this particular criterion. Basically, USCIS, the officers reviewing your case, they're not experts in your field. They don't have the ability to read your work and say, this is significant or it's not. They rely on other people working in your field to make that determination for them. And citations are a really easy way for the government to say, okay, this person's been cited 50 times in just the past year. That's a good indication that people in this field find the work to be significant. So we're going to say this criterion has been approved. Again, I don't want to make it sound like citations are the only thing that matters here, but they are a big factor, and we see as one of the best predictors of success for an O1, especially for this particular criterion. All right, getting to the last 3. Number 6 is published articles written by you. So this is the second criterion that pretty much everyone is going to claim, at least everyone who's a traditional scientist, researcher, academic background. If you have published any academic papers in any journals or conferences, you should be able to satisfy this criterion. So it's pretty straightforward. It's very black and white. It's not difficult for most people to satisfy. So this and judge of the work of others are the two that are pretty much easy for the majority of our clients. Like I said, you need at least 3. So those are the first 2 criteria. The key is really finding what that third criterion is going to be that's really strong. And we can claim more than 3. We can claim as many as you have good evidence for, but finding that third criterion tends to be the most important thing for most applicants. The 7th one here is critical role. This basically focuses on the actual role you have fulfilled in your work to date. So it can be a more challenging category for postdocs because usually a postdoc is not leading the research efforts in a particular lab. You know, they're not the principal investigator. They're not given super high titles or anything. So it can be more challenging. But what we want to show is that your individual contributions have been really important. And that is something that we can do for a lot more cases than you might think. If you're working on an NIH-funded grant and your advisor is the principal investigator, and he writes a letter saying that your research was key to making that study successful, or securing additional funding or something like that, that could be a critical enough role to satisfy this criterion. So it's thinking about what you individually have actually done and how you've contributed to the success of the organizations that you've been a part of. That's kind of the key for this criterion. And then the last one, high salary. High salary is pretty straightforward. We're typically looking for something like 90th percentile. Now, you're going to be compared to your field at large. So we're not just comparing you to other postdocs, for example. That can make it more challenging, but it doesn't need to be past salary. If your employer for the O1 is offering you a salary that is significantly higher than most people in the field receive, that's something we can potentially highlight. Even though you haven't received that salary yet, you will in the future. That can still be worthwhile. So a lot of these criteria really might seem on their face to be directed towards later career individuals, but we can make them work for a lot of people who are earlier in their career, just depending on what personal evidence you have. So that's kind of an overview of the O1. The O1 and H1B are not the only options. There are other options available. They largely depend on your country of citizenship. So things like a TN visa, which is available for Canadian and Mexican citizens, an E3 visa, which is available for Australian citizens. The other potential visa that a lot of people will consider is a J1, because that doesn't tend to be limited to any particular nationalities. The J1 can be a double-edged sword in some cases. A lot of J1s come with a requirement called 212E, or the 2-year home residency requirement. Not all of them, but a lot of them do. And maybe some of you are on J1 already and are familiar with this. But if you're looking for a J1 in the future, it's something to be cognizant of and aware of. It can make changing from J1 to another status difficult, if not impossible. And it can make a green card application difficult, if not impossible, until you satisfy that requirement, which involves going home to your country for 2 years. So basically leaving the US for 2 years period of time, or getting a waiver, which, depending on the circumstances of your specific J1, might be pretty easy, might be difficult to impossible. So the main thing I just want to say with J1, it is something that a lot of places offer. It is something that maybe a lot of you will be considering in the future. Make sure you understand, does the J1 come with a 2-year residency requirement for you? And if it does, how easy or hard is that going to be to waive that requirement? Especially if you're looking for a green card in the future, that's a thing that is really important to know. So that wraps up the presentation here. With that, we're happy to take any questions anyone has. You can either unmute yourself and talk, or feel free to send them in the chat, and we will answer as many of them as possible. And I'll just mention real quick, we do have a green card seminar next week that we'll be presenting on. And so we'll get a little bit more into some of the green card options available if that's something people are interested in.
Hello, can I ask a question?
Of course.
Thank you so much for the presentation. I want to ask about how do you assess the difficulty of getting a 212E waiver for a J1 visa?
Yeah. So it's really going to depend on the specifics of the J1, your country of nationality, the funding for your program, and the type of work that you're doing in your program. So some people will be subject to 212E because they come from a country that is on what's called the skills list. The basic idea there is that the skills you're gaining in your J1 program, you're supposed to take back to your home country to apply them there. Other people will be subject because they receive government funding. Any government funding is going to subject you to 212E. And then the third major reason is if you have a J1 for clinical medical work. So a clinical J1 will also subject you to 212E. And the reasons that you might be personally subjected are going to determine how easy or difficult it is to get a waiver. I will say skills list based on your country of origin, that's going to be the easiest situation to get a waiver. If you have government funding or have a clinical J1, waivers are going to be much more difficult.
All right, thank you.
Yeah. So I see a question here in the chat. If J1 with 212E apply for H1B or O1 without waiver. So if you have a J1 currently, you're subject to 212E and you don't have a waiver yet, you cannot get an H1B. An H1B would not be an option for you. An O1 would be an option, but only if you leave the US to go through consular processing for the O1. So you cannot change status from J1 to O1 if you are subject to 212E. You can't do that in the US. You would have to leave the US for that. Let's see, another question here. As a university, is Duke a cap exempt employer for the H1B? They would be, yes. Any university is going to be cap exempt. And how do I know if my J1 has the 2-year bar? So typically it'll be on your visa stamp and your DS 2019. If it is not on those two documents, you can request an advisory opinion. The Department of State will give you an advisory on whether or not you are subject based on the circumstances of your J1.
I have a question here. Hi, I am Salil. I have a question about the citations that you were talking about. So when someone apply, how much citation do you actually prefer? Like, is it like on the order of 100, on the order of 20s? What do you really?
Yeah, so it's definitely not black and white. There's no like magic number that's going to make sure you satisfy the requirements for an O1, but broadly speaking, more citations equate to a higher chance for approval. I would typically say 100 citations would be quite strong for an O1. I have seen people with 10 to 15 citations be successful for an O1. So really there's a very broad range. And I don't think it's as easy as saying there's a hard number. I think if you want to have like very, very high chance of success, 100 citations is a good kind of threshold there.
Okay, so I'm just the reason I was asking is about that citations are very much subjects field specific.
Yeah.
And do you have, is there a kind of categorical citation cutoff that is there? Like, for like science field, like for example, physics, chemistry, something like different than statistics. It's kind of, that's what I was talking about. Do you
Yeah.
have anything?
Yeah, I mean, in theory, it should be very field specific. The requirements are all framed in terms of compared to your field, but in reality, USCIS does not tend to look at your specific field, in my experience. So whether you're in, the social sciences or medical biology, where citations are going to vary, quite widely there, USCIS is going to treat it the same way. They kind of just see citations as citations and don't get more nuanced than that, even when we try to explain to them.
Okay. All right. Okay. All right. Thank you.
I have a question.
Yeah.
I'm Tilimri Chaudhary. I'm on J1 visa and recently got transferred my sponsorship from Emory to Duke University. So can my new visa be stamped inside the USA?
So what visa are you currently on?
J1.
J1. I believe only H1B can be stamped inside the US, right? Right, Natalia?
For the domestic side, yes, that's true.
So only H1B is eligible for that.
So I need to go to my country and I need to come back, like get the stamp and come back.
Yeah.
Okay, thank you. And I have another questions like since I'm not subject to the section 212E, it is written on my visa. So like how can I be eligible for, like, am I the eligible for J1 change to H1B?
Yeah.
If you're not subject, right, yes. I mean, we'd have to verify with the documents. Sometimes there are errors. I don't know, Andy, I think you've seen in your practice too, where
Yeah.
they say you're not subject, but you might be, there might be some government funding or something like that. But as long as you're not subject, then yes, you can do a change of status to H1B, whether with a cap subject or a cap exempt employer in country.
Yeah, thanks so much.
Just looking at the chat, a few more questions. How easy is it to extend a J1 compared to transitioning to an H1B? The J1 extension is certainly easier than that transition, but there's a 5-year limit on the J1. So at some point, that's not an option anymore. But as long as it is, that's definitely the easier path. What kind of timing should I expect of trying to transition from F1 OPT to O1 or H1B? So I'll speak to O1. The O1, the most time consuming part of the O1 is the case preparation. I would say expect 2 to 3 months to prepare an O1 case and get it filed. Once it's filed with premium processing, you can get a decision in 15 business days. Even without premium processing, 2 to 3 months is the average processing time. So relatively quick in terms of how USCIS does things. It's not automatic, it's not going to be like a couple-week turnaround in most cases. So it is something you want to plan out a little bit, but it shouldn't take more than a few months in most cases.
And in regards to the H1B, depending on if it's for a cap subject or a cap exempt employer, of course, if it's cap subject, the processing time is, the overall processing time is similar to the exempt ones, but of course the lottery process. So having to know when the lottery is done, which is in March of each year. And then of course the effective date again is in October. So you want to plan those early. If it's a cap exempt employer, then potentially you could get a case turned around in 2 to 3 weeks if they move pretty quickly. Going through the process, and then of course another 3 to 4 months for it to get adjudicated at USCIS, or 15 business days if you elect for premium processing. So a little bit quicker than the O1 overall, but it really depends cap subject or exempt.
So if I don't opt for the premium processing in the H1B exempt one, you were saying it takes about 3 to 4 months? Or what is that? They are like, what do they say in their website? Is it like 6 months, or it can go forever?
So each service center, so they go to different lock boxes and they have processing time. So depending on which employer, which lockbox would handle the case, we can check to see what their processing time is. It sometimes changes. In practice, I've seen most of my H-1Bs get approved in 3 or 4 months. It could take up to 6 months if you're going under regular processing, but turnaround time, like at Ellis Porter, for us to get the company all set up so that, or the organization set up so that we can then file the LCA, they get that certified. That
Yeah.
takes about 2 to 3 weeks. So that's the average time. And of course, if you're doing a change of status, you don't assume the H-1B until it's approved. So you'd have to maintain the OPT throughout or whatever your underlying status is.
Okay. Yeah. All right.
Another question here, without the waiver, but with an advisory opinion indicating that the J is not subject to 212E, can I apply for an H-1B or an L-1? Natalia, do you want to talk about whether the advisory opinion is enough for you?
Yeah, for the H-1B, I have not filed with that. I've always only filed with the waiver. I did file a change of status while the waiver was pending. And by the time that the case was adjudicated, they must have connected somehow, and they were able to approve the change of status. We told the client that it's possible we would get a consular processing case approved instead, but apparently they communicated and I was able to get it, but not just with the advisory opinion on my end.
Yeah, I will say with the J1, 212E, we have requested change of status for an O1, even when they're subject to 212E, and hoping a waiver comes through. And even when it didn't, USCIS approved them for change of status, so they probably shouldn't have, but we were not going to argue with them. So it, USCIS messes up sometimes, is the point there. Since postdoc appointments are a yearly contract, H-1B is not an option. Would an O-1 be better? Potentially, yeah. An O-1 you can do on an annual basis, but the length of time you're given for an O-1 is going to depend on how long your job goes for. So if the university is only willing to say, like, you have a 1-year appointment, they're only offering you a position for 1 year right now, you can get an O1, but it's only going to be granted for 1 year in that situation. The maximum time you can get on an O1 is 3 years. It can be extended after that, but that initial O1, the length you get is going to be dependent on how long you're being offered a job for. While you're waiting on the H-1B lottery, can you also file for an O1? Yes, you can. You can pursue multiple non-immigrant options at the same time. It can get a little tricky if both of them are approved. You may, especially if like different employers are involved, you may end up on the status that you don't want. So you have to be a little proactive in, like, if you get approved for the one you want, withdrawing the other one, making sure that you're not ending up in the status that you don't want. But yes, in theory it can be done. It just requires some logistical coordination, I would say. I have a J2 and I'm working as a researcher now, but I will apply for medical residency, so my visa will be changed to J1. Should I apply for waiving J2 this year? If yes, when? I do not believe you would need a waiver to go from J2 to J1. Natalia, do you know that more clearly?
I mean, historically, the way that I've understood the J1, J2 rules, that, I mean, as long as you don't need to get the waiver to go back to the J1.
Right.
It's only to switch to another non-immigrant status. This doesn't allow it. So
Yeah.
I've never had anybody go back and forth, but I imagine because they're subject. So you wouldn't need a waiver there.
Yeah. So you need the waiver, at some point if you wanted any other visa status or to get a green card, but you shouldn't need it to go to the J1. Can J1 be extended after waiver? I would say typically no. I would not expect a J1 to be extended after you get the waiver. You've kind of demonstrated that you don't intend to comply with the terms of the J1, so they're not going to extend the J1. If they did, I would say you could potentially be re-subjected to 212E and have to get another waiver. So I would typically recommend extending your J1 as far as you can before you do the waiver. Have a question. Does the fact that I'm considered stateless have any effect on this process? I don't have a great answer for that. I don't know if you do, Natalia.
I have not had anybody, you know, be considered stateless and handling any type of their immigration process. So I understand what it means, but I don't know if there would be a technicality on not being eligible for any immigration benefit because of it.
Yeah, I'll take this opportunity to say our email addresses are up on the screen here for like very case specific questions. Feel free to reach out to us, and even if Natalia and I can't answer the question, there's probably someone at Ellis Porter who can help. So we'd be happy to get you in touch with the right person. That might be a good one to reach out to us, and we can get you in touch with one of our attorneys who's maybe more familiar with that. How long does the J1 visa waiver process take? I think 4 to 6 months is what I have heard recently. So it's not an immediate process either. How long should I expect to switch from F1 STEM OPT to H4 visa? You know, the timeline for that kind of change of status to H4?
Yeah, there's no premium processing option. Average time is about 6 months. That could be depending on.
I don't know if
if
it's
you're-
just me. I can't hear you, Natalia.
Sorry, Andy, how about now?
Not getting anything.
It might be on your
We
end.
can't hear you.
Andy, we can hear you.
You can-
We can
okay.
hear both of you actually.
Thank you, Thomas.
I don't know what happened. We just lost your audio there.
Sorry about that. So how long it takes? So standard processing time is about 6 months for the change of status from F1 to H4. There's no premium processing option yet. There is supposed to be some. Potentially, if applying for the change of status concurrently with your H-1B principal spouse or parent, it could speed up adjudication a little bit more. But overall, the processing time could be closer to 6 months, 4 to 6 months for a change of status from F1 to H4.
Thanks. Sorry, somehow I got muted there and couldn't hear anything, and got it now. Let's see. How does changing jobs affect having an O1 visa? That's a great question. You can change jobs. You will need a new O1 petition, however. So if you're on an O1 and you want to take a new job, the new employer will have to sponsor you for an entirely new O1 petition. So it can be done, but got to go through the process all over again. If my current employer does not extend my contract, could I keep my J1 status with finding another employer? Yeah, if you find a new employer to transfer your DS 2019, you should be able to keep your J1 status that way. It's also, do you know if there's any specific visa that can be used for physical therapy residency programs, or do we have to use our OPT year for that? I am not familiar with physical therapy residency programs. I assume, Natalia, you're not either. We do have a healthcare team at Ellis Porter, and they would probably be more privy to things that go on with different residency programs and what options are available. So I'd say that's another great question where if you want to reach out to us directly, we can put you in touch with our healthcare team and help you get some better answers there.
I have done an H-1B for a physical therapist later after the residency. So it's not that H-1Bs are off the table for that. It's not just for certain fields. I mean, it's just for anything that requires a bachelor's degree. So.
Can I ask a follow-up question on the physical therapy thing?
Sure.
So how easy it is to find an employer who would like to sponsor a H-1B visa for a physical therapist?
How talented are you, Joy? Because I think that's what it comes down to. I mean, employers are willing to do it. Sometimes they get intimidated by the process. I mean, what I do is I usually consult with the employer directly and try to explain that it may seem labor intensive, but it's really not. We take a lot of the burden on having the paperwork. But if you have the talent and the credentials for the role, and the employer can truly say they want to sponsor you for it, that's fine. It's not a willing, able, and qualified U.S. worker to do the job kind of test. It's not a labor market test for an H-1B. You just have to prove that there's a job offer and the person has the credentials to be a physical therapist and the company wants to, or the organization or clinic, wherever it might be, wants to sponsor that person. So I've had companies approach me or organizations do it, and hasn't been an issue. But it's also sometimes, based on the area too. Some companies are just, harder to find the talent, and that's why they're willing to do it.
Okay. All right. Thank you. I'll look for jobs in rural areas.
You're picking up what I'm laying down. I mean, that actually is where I got most of that client base from. But that seems to be where that talent has to be. So good luck. Keep us posted. We're happy to consult with you or your employer.
Thanks.
Have a few more questions here about J waivers. I'm going to post in the chat a link to DOS's website about the waiver process. I think that's a good starting point to kind of learning about the waiver process and what steps there are. It's going to depend on the reasons why you're subject. So, it's very case specific and hard to generalize, but we do have a waiver team at Ellis Porter. So if a J waiver is something you're interested in, you look through the website and think I would like to retain an attorney for this, definitely reach out to us. We have a team that handles just waivers. So definitely something we can assist with. Let's see. So there's a couple of questions on J1 subject to 212E, residing in a third country. I'd say those are pretty case specific, so that'd be a good one to reach out to us directly on rather than trying to address here. How much would this process cost? Should it be done through immigration attorneys only? So it depends what process you're talking about, whether it's a waiver or an O1 or an H1B, the costs are going to change. I would say there are a lot of advantages to having an immigration attorney. And I know that we're a little biased and we would think that, but mistakes are easy to make on these applications. And it definitely helps to have somebody experienced who knows what they're doing, who knows what to look for, who knows what kind of mistakes are going to lead to problems, and to be on the lookout for those. So I think that there is always value in consulting with an immigration attorney. Can some things be done on your own? Absolutely. And I think it just depends on your comfort level there and your willingness to accept some level of risk that, as somebody who's not as experienced, you might be more prone to make a mistake somewhere. Will EB2 NIW or labor certification for Schedule A be covered next week? We'll definitely cover NIW. I don't think we cover Schedule A specifically, but we will do some of the EB2 perm stuff as well. Does H-1B extension process with the same employer take similar time compared to the initial petition?
Each lockbox has their own processing time, but typically no. I mean, I would say that it's shorter. It should be shorter because it's really just a recap of the last petition if it's just a straightforward extension, but there is still subject to the same general processing time, which could be 3 to 4 months.
There's also a question here, do hospitals hire more foreign physical therapists or private clinics? I think it's going to be very case specific. I think that's a situation where you've just got to start exploring your employer options and, seeing what they're willing to do. It's going to vary from place to place. Any other questions? I think we've got through them all right now. Like I said, feel free to send either Natalia or I an email. If you have more specific questions or want to get in touch with an attorney who can help you with some of whatever issues you face, Ellis Porter, full service immigration firm. So we're happy to help in any way we can. So feel free to reach out. And just I see one last question there, just to make sure no waiver is needed for J1 to O1. So you can do J1 to O1 without a waiver. You will need to go through consular processing. So you'd have to leave the US to get the O1 visa and re-enter the US. You cannot change status in the US without the waiver. What's the chance of waiver approval if no government funding? So it's going to depend in part on your home country and how willing and quickly they will sign off on the waiver process. But I would say if you are subject due to the skills list, that is the most likely way you're going to get a waiver. So that's the best case scenario.
I have a question, just last question I have. So when you guys file H-1B for someone, for an applicant, is it required for you to sign any documents by that person? Or do you send the file documents? It just wanted to because I mean, Duke filed an application for me. I have only got to know that they have filed for me. I don't know when they filed, or I don't know, like the application document they never sent me. I just don't know whether it is customary to ask them about the documents, or is this something for me to like I just don't know whether it is like really essential for me to ask them about what I want to see the application file and everything. I mean, I know that they have filed the application for me, but I don't know I did not see the application file ever.
And I don't know if I can, put an amount on how unusual it is. In my experience, well, first off, let me back up. You do not have to sign anything as it relates to the H-1B in terms of the forms or anything. That's all going to be signed off by your employer, the petitioner. You do have to provide documents because the supporting
Yeah,
documents.
I sent them the documents long before. Yeah.
Yeah. So, I mean, I don't know, Matt, that might just be their policy or what have you. You will probably need a copy of the 129 forms when you go for stamping, if you ever decide to go. But I don't know why it wasn't sent to you or anything, but technically, yeah, you don't have to have reviewed anything or signed anything because it's nothing that you would have reviewed or signed. It's all about the company.
Okay. Yeah. Okay.
All right. I think if there's no more questions, that's it.
Excellent. Well, Natalia, Andy, thank you so much.